Hello and welcome to the channel. This week we are going to talk about the best way you can prepare to win a case at tribunal. So the scenario currently is that you are employed by your employer and you're either going through a grievance process or a disciplinary process, but you have a workplace dispute. And this channel is all about supporting you during your workplace dispute and giving you the best possible chance of winning at tribunal. Now, tribunals really take a dim view of employers that do not follow their own policies and procedures. So if you're going through a process at the moment and you find in any field that your employer has not followed the correct process or policy that they have written down in their handbook, then please document it and gather as much evidence as you can, because if you use it later on in tribunal, you will find that that will be enormously helpful to you in your case. Tribunals take a really dim view of employers that go to all the trouble of writing policies and procedures and then find out that line managers just do not follow them. So if you have a situation like this, document evidence, record, and then you can use it later on. My next tip is record meetings. Now, if you go into a disciplinary meeting or a grievance meeting with your employer and you whack your iPhone on the desk and you say to them, can I record this meeting? I think we need to have a transcript of it. 9 times out of 10, they will say no. And they will say no because they want to control the narrative. They want to be absolutely 100% sure that no line manager in that room is going to say anything very silly or anyone is going to say anything that can come back and bite them. But my advice to you is record it. Now, whether you ask permission or whether you record it covertly is entirely up to you. Now, if you record it covertly, you need to take extra care. If you're currently employed and you remain employed by your employer, do not reveal to them that you have covertly recorded a meeting. Even if it's a disciplinary meeting, do not reveal that you have recorded it until after you have been dismissed or until after you have left the company and you're in tribunal proceedings. You make the application to the tribunal, and if you need help doing that, then we have a template on our website that you can download and fill in. But if you disclose to your employer that you have covertly recorded a meeting, then 9 times out of 10 they will have a policy which says that you are not allowed to do that, and if you do that, they can dismiss you. So regardless of what process they were following that caused you to record the meeting, whatever disciplinary it was or whatever you were going through, whatever dispute you were going through, they can park that and they can say, okay, we'll just pause that for a moment. We're now going to start proceedings against you for covertly recording a meeting which breaches confidentiality and breaches XYZ policy. And that could lead to dismissal. And so they don't need to pursue their original strategy. You have given them on a plate a reason to sack you. So keep covert recordings to yourself until you absolutely have to, and absolutely have to means disclosing them to a tribunal. If you need to use the evidence that's on the covert recording, then just say to them, yes, such and such said such and such, and that is taken from my contemporaneous notes. Those are my notes, those are my recollections of the meeting. That absolutely happened. No matter how many times they deny it, just stick to that line. You do not have to tell them that you covertly recorded the meeting until you disclose it to the tribunal. My next tip is on appeals. Now, appeals are usually just rubber stamped decisions upon decisions that are taken to dismiss people. And people, line managers usually carry out appeals, and line managers usually just rubber stamp decisions that are taken before they hear them. We all know that. But your job is to go through the motions, to go through the process, and to treat it as a serious evidence gathering exercise for you at a tribunal, for when it gets to tribunal, because appeals that are not conducted properly or thoroughly are really negatively looked upon by a tribunal. Tribunals will take a dim view of any appeal process that is not robust. And so if you can just document and take a very impartial view of the appeal process, write everything down, write the process down, write what was said down, what meetings were held, what meetings weren't held, who held them, then that may actually help you later on in tribunal. Now, while we're talking about appeals, let's just digress a little bit on disciplinaries, because if you're going through a disciplinary process, one of the things that you can do to try to halt the disciplinary process is to raise a grievance. And you can raise a grievance on 3 grounds. You can challenge the process, you can attack the decision maker, or you can attack the investigating officer. And the better option is to attack the investigating officer, and hopefully the investigating officer, the person who carries out the investigation against you, is someone who has held a grievance against you or has shown some kind of discriminatory language which is relevant to your case. Now, this is probably the strongest and most useful way of halting a disciplinary process by raising a grievance. The other 2, perfectly valid, but they can actually be remedied by the employer quite quickly. If you challenge the process and say you did not follow the correct process, then all they have to do is follow the correct process, and that puts an end to the grievance. If you attack the decision maker, then all they have to do is replace the decision maker with someone else, and they only have to offer you up to 4 decision makers before they can carry on without worrying that a tribunal would hold it against them. So very quickly those grievances can be closed out. Attacking the investigating officer is a much better way. Now, let's carry on. So, best way of gathering evidence to win a tribunal from employers who allow banter to get out of hand. So if you're in a disciplinary process, or you are part of a disciplinary process that involves office banter, which has got out of hand, and you are now being disciplined for saying something or doing something which has previously been allowed by the company or encouraged by the company or even carried out by directors or senior managers themselves, then gather evidence, because that is worth weight in a tribunal, and tribunals take a very dim view of employers that do not enforce rules fairly and consistently. Also, consider whether your employer has not addressed previously employment related issues, performance issues in particular, with other employees. Now, if that's the case, gather evidence about it. It's relevant, whether it's of direct relevance to your case or whether it's slightly different. Gather evidence. The consistency or inconsistency that you're looking for is that your employer does not deal fairly with performance related issues, and therefore you can rely very safely on the assumption that you shouldn't be subject to disciplinary proceedings for performance related issues because they haven't held other people to account for them in the past. So if that's the case, gather evidence. Very usefully, which is another tip, very usefully, if your employer does not deal with grievances in a similar way that it doesn't deal with performance issues, then that too is very relevant to a future tribunal case. Tribunals take a very dim view of any employer that doesn't take grievances seriously and doesn't investigate them properly. Now, there is case law which says that grievances should be investigated within a certain amount of time, and if they're not, it can be taken that you have been constructively dismissed. That amount of time is 3 months, so an employer has 3 months in which to deal with your grievance, and certainly ACAS codes of practice will support any strategy in that vein. If you need help raising a grievance or drafting a grievance letter or an appeal, then we have those templates on our website. Just head over to the website tribunalclaimshub.com. And my final tip is not allowing you to have representation at a disciplinary hearing. Now, the Employment Relations Act says that you have the right to be accompanied by a trade union representative or a workplace colleague. However, if under reasonable adjustments, you, for let's say mental health reasons, cannot follow a meeting in a normal way, particularly in a stressful situation that comes with a disciplinary, it's perfectly acceptable for you to ask to be accompanied by someone you know, someone you trust, someone who has helped you before, and someone who can assist you to, in particular, understand the proceedings. Now, if an employer refuses that adjustment and they just say, no, trade union representative or workplace colleague only, otherwise you're on your own, then a tribunal will take a very dim view of that, and the Employment Relations Bill is certainly relevant because that sets a minimum standard. It's not the only standard. So most of what employers put into their policies and procedures in terms of being accompanied is taken directly from the Employment Relations Bill, and what they don't realise is that's the minimum standard and not reality. So if you have a reasonable adjustment, if you have a mental health condition, for example, or you're hard of hearing, or your eyesight is poor, or whatever it is that you need assistance with, and you have someone who regularly assists you, who you trust, and who can accompany you to help you work through the stressful situation that is undoubtedly going to follow with a disciplinary, then make the request. If they refuse it, say to them, I'd like it to be placed on record that I've made this request and I may introduce this in future at any further proceedings that I choose to take. Don't fight them on it, just go along with it, but make sure that you have your objection documented and recorded. Now, if you need any help, head over to the website tribunalclaimshub.com. We have templates and letters for you to download over there, or you can book a coaching call with either myself or one of my colleagues who can actually help you work through the technical aspects of raising a tribunal claim, writing your ET1, or at any point throughout the tribunal proceedings, we can help coach you on any document or template that you may need, or help you to understand any of the legal jargon that comes up. Best of luck with it. Please, if you're new to the channel, like and subscribe the video. It costs absolutely nothing. It really helps the channel, and I look forward to seeing you on the next one.